For decades, millions of Americans have been told that self-defense is not a good enough reason to carry a gun in public. In places like New York, California, Hawaii, or Maryland, ordinary citizens could pass background checks, maintain a spotless record, train responsibly with firearms, and still be denied the right to carry outside their own homes. Why? Because bureaucrats demanded proof of a special need, as if your life was not valuable enough without a police report or a direct threat attached to your name. But in 2022, that narrative collapsed with a thunderclap, and the aftershocks are still shaking America in 2025. A single Supreme Court ruling, decided by a 6-3 majority, didn't just open a door, it blew apart a century of legal gatekeeping around the Second Amendment. Today, we're diving into exactly what happened, what the court said, how states are reacting, and why this one decision is reshaping gun rights across the entire nation. To understand how explosive the ruling was, you need to know the world before it. For more than 100 years, New York's Sullivan Act and similar laws in other states gave government officials absolute discretion over who could carry a firearm in public. It didn't matter that the Constitution promised the right to bear arms. It didn't matter that you had passed every background check. Unless you could prove a specific threat like someone stalking you or a string of documented attacks, you were stamped denied. Self-defense wasn't good enough. This created a two-tiered system where only the politically connected, retired law enforcement or business owners handling cash could realistically secure a permit. Everyone else was left vulnerable, unarmed by law, in some of the most dangerous cities in America. This was the environment that finally gave rise to the perfect legal challenge. On June 23, 2022, the Supreme Court handed down its decision in New York State Rifle and Pistol Association v. Pre-Bruen. Justice Clarence Thomas wrote the majority opinion, and for gun owners across the country, it was like the clouds finally parted. The court declared that the Second Amendment is not a second-class right. If you are a law-abiding citizen, you do not have to beg the government for permission to defend yourself in public. The right to bear arms does not stop at your front door. The 6-3 ruling struck down New York's proper cause requirement and, by extension, cast a shadow over every similar law in California, New Jersey, Maryland, Hawaii, and other states that had been using the same discretionary system. The importance of this ruling cannot be overstated. For decades, lower courts had used balancing tests, trying to weigh whether public safety outweighed individual rights. Bruen threw that out completely. Instead, the court set a new standard: modern gun laws must be consistent with the nation's historical tradition of firearm regulation. In practice, that means if a state wants to ban carrying firearms in subways or limit magazine capacities, they must point to a similar restriction from the 18th or 19th century. If no such historical example exists, the law is constitutionally suspect. This text, history, and tradition test changed the game. It stripped away the wiggle room states had used for decades to justify restrictive laws. Judges could no longer say, well, maybe this law does more good than harm. That excuse was gone. But the battle did not end there. States like New York and California immediately pushed back. Within months, New York passed the Concealed Carry Improvement Act. On paper, it was supposed to comply with Bruen, but in reality, it was a direct act of defiance. The law created vast, sensitive places where firearms were banned: Times Square, public transit, parks, churches, even private businesses, unless they posted a guns welcome sign. California followed with Senate Bill 2, designating over 20 categories of restricted areas and adding extra permit hurdles. New Jersey and Hawaii rolled out similar measures. They claimed it was about compliance, but in truth, it was about slowing the spread of concealed carry by any means possible. The result was a new wave of lawsuits. Federal courts in New York and New Jersey quickly ruled that parts of these sensitive place laws went too far, issuing injunctions that blocked enforcement. Appeals are ongoing, and the legal chaos is spreading. Lower court judges have admitted they now feel like historians, combing through centuries-old laws to determine whether modern restrictions can survive. In some cases, they've upheld bans. In others, they've struck them down. The inconsistency almost guarantees that the Supreme Court will be forced to intervene again. Beyond the courtroom, the effects are real and measurable. States with streamlined permit systems like Utah and Indiana continue to report high compliance and extremely low misuse rates. In Florida, for example, the annual revocation rate for concealed carry permits is less than 0.1%, proving that law-abiding citizens are not the problem. Meanwhile, states dragging their feet, like California and Hawaii, have seen massive backlogs. In Los Angeles and San Diego, applicants often wait more than 6 months. In Honolulu, lawsuits forced the police department to agree to process applications within 120 days and build a new online system by 2026. It's not outright denial anymore, it's bureaucratic attrition, slowing people down until they give up. The numbers tell another story. Demand is skyrocketing. In Washington state, active concealed pistol licenses reached over 709,000 in July 2025, the highest in state history. Across the country, more Americans are choosing to arm themselves legally, even as some states try to resist. The tug-of-war between constitutional rights and state-level resistance is fueling an arms race of lawsuits. Every week, new challenges are filed, not just against carry restrictions, but also against bans on so-called assault weapons, magazine capacity limits, ammunition regulations, and transport laws. Judges are citing Bruen directly, arguing that if the Founding Fathers didn't ban muskets or powder reserves, then modern bans on AR-15s and 30-round magazines may not survive constitutional scrutiny. The stakes could not be higher. In 2023, a federal judge struck down California's magazine ban, explicitly pointing to Bruen's historical test. Illinois' assault weapons ban is under fire from the Firearms Policy Coalition and Second Amendment Foundation. Even non-lethal restrictions like New Jersey's requirements for transporting firearms in locked containers are being challenged. In short, Bruen was not the end. It was the beginning of a constitutional arms race that is still unfolding in 2025. So what about public safety? Critics predicted blood in the streets, claiming that more guns in public would unleash chaos. But the data doesn't support those panic headlines. The Rand Corporation reviewed over 100 studies and found that shall-issue carry laws might correlate with modest increases in violent crime, particularly in urban areas. A Stanford study showed a 13 to 15% rise in violent crime over a decade in some states with relaxed standards. But here's the key. None of those studies blame law-abiding permit holders for driving up crime. Instead, the picture is complicated by factors like poverty, gang activity, and policing levels. Meanwhile, states with strong permit systems report low misuse, and revocation rates remain microscopic. The evidence suggests that Bruen has not created chaos. It has simply forced states to face the reality that responsible citizens want their rights respected. As we stand in 2025, the legacy of Bruen is clear. The Second Amendment has been restored to its rightful place as a fundamental right, not a privilege granted by bureaucrats. Yet the fight is far from over. States determined to resist will continue to pass restrictive laws, and gun rights advocates will continue to challenge them in court. The Supreme Court will almost certainly be called upon again to clarify the boundaries. And for gun owners, the landscape remains both promising and uncertain. In conclusion, the 6-3 Bruen ruling was more than just a case about concealed carry. It was a seismic shift in the way courts must interpret the Second Amendment. It dismantled a century of gatekeeping, set a strict new standard based on text, history, and tradition, and ignited a wave of challenges against every form of modern gun control. Whether you see it as the restoration of liberty or the beginning of chaos depends on where you stand. But one thing is undeniable. The Supreme Court has redrawn the map, and the fight over America's gun laws is entering a new chapter. For gun owners across the country, the message is clear: you no longer have to prove that your life is worth defending. The Constitution already did that for you.